Jamie, did you want to say
Well, no,
something?
but I think we're kind of getting to the heart of whatever disagreement we've got here. I mean, let's see, would you accept, just hypothetically, if there were only 20 radio stations in the country and it was a public resource and it was given to those stations, that they would have an additional public interest obligation that could constitutionally be imposed upon them? For example, not to exclude political candidates from debates that they put on the air? Or do you think that regardless of how small or how large the spectrum is, that the minute you describe it as private, even if they've been given the license, they can do whatever they want?
No, you set up these hypotheticals. First of all,
I'm a law professor. That's what I do for a living.
Well,
don't fight the hypothetical.
I will contribute to your hypotheticals.
Okay.
Here's a hypothetical. Let's talk about what we've done. As soon as you have the public interest power in place, what do they do with the public interest power? They restrict the amount of speech. So you're saying, well, the speech is going to be restricted under the market. The market expands speech. Now, if there's an antitrust problem, if there's a consolidation
the
problem,
market may or may not. I mean,
you can handle that through antitrust, through deconcentration policies, and the way we already handle it, and apparently is irrelevant, and that is to publicly fund something that's a competitor. It's called the public option, excuse me. And in fact, apparently that counts for nothing. But these are private competitors in the marketplace. And you want to say, well, let's arbitrarily restrict it to a small number, and then all of a sudden can we have different rules? Well, not under the Constitution. Because the Constitution, in fact, was written at a time where there was a far more concentrated press market in terms of not having the media outlets that were available. And there's this idea that Red Lion had some kind of market power relative to the newspapers in the 1700s is ridiculous. It had no market power. There's no 20 radio stations and one of them is Red Lion, therefore they have to perform in this fashion. This is not the way the law is applied, and the First Amendment should protect against that.
Sure, but the law didn't apply exclusively to Red Lion. It applied to all radio stations. So there would be a problem if you were running for office in a particular jurisdiction and a major radio station wouldn't allow you to get on the air and endorse your opponent. So
and if the big newspaper called the Miami Herald attacks you, yes.
Well, right, except one is occupying a public resource and the other is not.
Well, that's arbitrarily defined.
I'd like to ask how Governor-elect McDonnell thinks about the Washington Post. I mean, that was a serial set of attacks for months by the Washington Post. Not one isolated incident like the Miami Herald. So I don't think there's a justification for censorship based on one or a series of attacks by a publication. I mean, that hasn't changed between then and now, and I don't think it's any justification to treat radio differently than to treat the newspaper.
Okay, but would you concede that if there's a state-run cable TV station, for example, like Arkansas Educational Television Commission, that it should not be able to, say, endorse one candidate for governor over another and promote it if this is the taxpayers' resources?
But it's not a matter of endorsing it. It's a matter of the coverage of it.
Both.
Yeah, but
say both.
That's still, the question is still valid. If it is a state-run station, should they have the limitation on it, if it's taxpayer-owned?
It gets into a nefarious netherworld when the government owns.
Well.
Yeah, but they do own. They do.
Look, here's the fact. The publicly funded enterprises, not just in the United States, but the BBC and all over, where the United States is actually unique in the amount of private broadcasting we have, and Germany and other countries, Australia, so forth, Canada, very big on public broadcasting, and that's what the government calls fairness. Okay, that's baked into that. That's a public subsidy, and you look at that broadcasting, you tell me that that's fair. I mean, that's fair by definition because the state is doing it. You don't need a regulator. The state's doing it directly. Well, yeah, that's what fairness looks like to the state. Okay, now, you can take that and run with it. Now, in fairness, yes, the court did say Miami Herald is different because there's a public resource in Red Lion called the radio spectrum. Mm-hmm. Guess what? They were wrong about radio spectrum and they were wrong about newspapers. 0 for 2. Newspapers. Well, to run a newspaper in the pre-internet age, and still now, you use public streets for delivery. Okay, this is a part of your business. And in fact, studies have been done to show that the incidence, the cost to local governments for newspapers is very, very high relative to, for example, to a cable operator that delivers signals through the radio spectrum. spectrum in a tube that runs along city streets that have to get a franchise, which is another problem and another First Amendment problem we have in our media market. The cable operator is actually franchised by the local government, and there have been studies done showing how the incidence on the public resources is much, much more onerous for the newspaper. Okay, they impose all kinds of, mostly, by the way, for trash collection because of that stuff that they used to be printed on at some point. And at any rate, the fact that they use public streets and the fact that they use public laws and the fact that corporations that get all these benefits, you know, can operate the Washington Post does not dilute the First Amendment rights of the Washington Post. They are a speaker. I don't know how the lack of free speech rights for a corporation enters into this. We don't want to shave those corporate rights because they own the newspaper.
Question I've got about that, Jamie, is you talk about corporations not having First Amendment rights. I don't know of a newspaper that isn't owned by a corporation these days. Do they not still have the same First Amendment rights they did?
I don't think they have any of the First Amendment rights to engage in political activity. I think because we have a free press clause, they have the right to operate as the press.
How would you?
Where's that in the First Amendment?
The freedom of the press, it is in the First Amendment. Yeah. There's 6 rights in the First Amendment. Press is one of them. Speech, press.
So not political
if the
speech.
corporations do not have the same rights as individuals, are you saying then that they do not have the right to endorse candidates because they're owned by a corporation?
No, I would not say that. I think that is within the right of the freedom of the press. But I think, does that mean that because the Washington Post can endorse Deeds for governor, that the Washington Post could put $10 million into his campaign or spend $50 million on behalf? Absolutely not.
What if the endorsement's worth $12 million?
Yeah.
Well, you know, if you read the newspaper, and I mean, I'm sure nobody here does, but I mean, if you read the newspaper, you choose to affiliate with the newspaper, you know what's going into it. You can either buy it or not. I thought
what would it cost to get that same space on the newspaper's editorial page or an equivalent page if you were not owning the newspaper?
$12 million.
Yeah.
Yeah.
And any individual citizen can purchase that. But
no, it's at the discretion of the newspaper owner, the corporation.
Well, sure, but
even though they're a corporation.
That's your argument.
No, it is at the discretion.
I mean, you don't have to sell it if you don't want to. No, the law is that corporations may not engage in political expenditures.
No, the newspaper can endorse.
Corporations may not make campaign contributions.
The newspaper can endorse and give an in-kind contribution.
I realize I started this, but now I'm going to stop it. And call on the next speaker lined up at the microphone. Next questioner lined up at the microphone.
Thank you, Judge. First, I'd like to suggest for the non-lawyer in the panel, it's never a good idea to tell a judge he can't sanction you.
I've done that several times, and I've never done more than 30 days for it.
Yeah. And I'm not a lawyer either, but I wouldn't have made that mistake.
I have a two-part First Amendment question, and so let me preface it by saying I understand Tom's point that spectrum really is not limited in the way the court said in Red Lion, but let's accept for purposes of discussion that it is. Let's adopt the premise the Supreme Court.
I didn't say spectrum wasn't limited. I said licenses.
Licenses. I'm sorry. Yes, licenses. Let's accept the premise that the Supreme Court had in Red Lion. In light of the fact that in recent decades we've seen the FCC auction off licenses, and given that First Amendment doctrine includes a requirement that we look for the least restrictive means, if the case were to come before the court today, do we really think the court would say you can impose an equal time requirement as opposed to you need to come up with a different way to allocate licenses? That's the first part.
That had a
Anybody
question
would care
mark.
to respond?
The question to the court would be,
If the FCC would
the court
say-
comes today post auctions.
Right.
The question for the court is,
The question for the court is the Fairness Doctrine the least restrictive means to ensure that we have this diversity of speech, that we get to hear opposing point of view? Or is there a less restrictive means, which is to say, look, if the whole hook here is that these are public airwaves that have been given to stations, maybe the problem is don't give them to stations, auction them off, and whoever buys them, you can't tell them they have to provide equal time. Under general First Amendment principles, do we think that the court would continue
yeah.
down the road it did in Red Lion.
I think your point makes good sense to me.